We're joined in studio by Mr. David Gray. He's a Deputy Information Commissioner at the Office of the Information Commission. And that office ensures that the Data Protection Act is being acted upon and compliance is there and so on. So we're excited to have this conversation. So over to you, Jade, as we start out.
Yes, so this June, we would have had an episode on the data protection framework where we were joined by some members of the private sector. And today, we will be focused more on what those legislative provisions are in this discourse. Now, the Act, as we know, was passed in 2020. And this year, December 1, it is intended to be fully enacted, so fully enforced, fully implemented.
There is a question that we're going to be probing as we navigate in terms of the regulations and when exactly those were passed, because I know they were being deliberated, I think, up to a month ago, but Deputy Commissioner can advise us on this. But with this implementation coming up December 1 and the requirements within the Act, such as companies being needing to have data protection officers and so on, and those officers needing to be somewhat independent within their office space. We've already heard from various private sector organizations that they're not too certain whether or not they can be fully compliant. So what are the implications with that lack of compliance, especially when there are financial implications and possibly the lack of human resource to fulfill some of these areas within the Act?
Yes, so to join us today, as we would have said, Mr. David Gray is here from the Office of the Information Commissioner, hopefully to shed some light on some of these questions that we have here. Mr. Gray, how are you doing?
I'm fine.
Great. Thank you so much.
You're welcome.
And by the way, for our listeners, we do have some right to privacy in our constitution, absolutely. But this is the first law that is on statute, I should say, that governs our right to privacy in this way. I don't think that was how it started out, though. It started out, and Mr. Gray can perhaps assist us with the background of the Data Protection Act so we can get a sense of where the state is going and how exactly we are protected. So before we get into the compliance and the accountability, what is the importance of this Data Protection Act for citizens?
Well, firstly, the Data Protection Act actually codified a constitutional right under the Charter, the right to privacy. What we have done now is to include in the codification the whole matter of data protection, meaning an individual's data being subjected to privacy rights, and actually putting the control over data in the hands of those whose data it is. So in looking at the Act, you will hear the term a data subject, which is actually you and I, and the data that is associated with us in whatever form it is, whether it is our name, whether it is our TRN, whether it is our NIS number, whatever number that can be associated with us and is used by various parties in normal day-to-day business activity. As your initial prompt showed, we have the right to ask certain questions in relation to our data. We also have the right to tell persons to stop processing our data. That is the level of control which the Data Protection Act has sought to give all of us so that we can manage our personal affairs and our likeness in this social sphere.
Yes.
And that we have control over it.
Thank you so much. Jade, I know you have probing questions, but interestingly, Mr. Gray, there was an article this week, I'm not sure if you saw it, Jade, wherein it flagged that there are certain questions that people were asked during the job application process that were very, very personal, matters around our health, medical records, and so on. Is there any protection or exemption regarding those situations?
Well, when you're going back to the specific article which I read, we are actually dealing with, when you touch on health records, you're actually touching on concerning sensitive personal data. And sensitive personal data under the Data Protection Act is given special treatment in that persons who handle it have to have in place a data protection officer. The whole matter of privacy in relation to this form of information and who will have access to it is also dealt with by virtue of the provisions of the Act. Now, because of the advent of the Data Protection Act, our office has been informing persons that they need to look at their procedures and policies which they may have in place over many, 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 many years to see that it is in tandem with the provisions of the Data Protection Act. And I would dare say that organizations need to look at this whole matter of health data and the purpose for which it is required in relation to the provisions of the Data Protection Act to ensure that A, there's no contravention of any rights that a data subject has, but that there, where one of the standards requires minimum data collection, that whatever that information which is deemed necessary for that organization's purpose is absolutely relevant to that entity.
Great, thank you so much. We're up on a break, but Jade will jump right back in when we return on the accountability areas. We take the break.
Welcome back to Let's Talk Justice. Today we are navigating the data protection landscape with Mr. David Gray from the Office of the Information Commissioner. We were just having an off-air conversation about our coming regulations and a bit about our implementation and what that would look like with December 1 looming upon us. So, Mr. Gray, I don't know, for our listeners, could you give us your what you can say publicly as to the regulations and that implementation process?
Well, last Wednesday, the minister did speak in the cabinet press briefing,
Yes.
and she indicated that the process of full implementation of the Data Protection Act will take place. There will be some modifications in relation to the full rollout, and over the coming weeks, the minister certainly will be making the relevant announcement as to exactly how December 1 will feature into the full implementation of the Data Protection Act. So I would tell all the relevant stakeholders and the public is that in the coming weeks, there will be announcements to allay all the doubts, allay all the fears as to exactly how December the 1st will be implemented over the period leading to the full process of implementation of that.
Great, thank you so much. And for purposes of the listeners, just to indicate that the Minister of Reference here is Senator Dr. Dana Dixon, yes. And the regulations, as you're very well aware of, but just worth repeating for listeners who may not be knowledgeable on these things, that the regulations tend to give the law teeth, make it operational. So to put that in context, that it is important that the regulations are so established and finalized so that we are aware of what the powers exist, what exactly we're being asked to be compliant with. So regulations are quite important for any law to really be effective. So we await the further information from Senator Dr. Dixon, as Mr. Gray just outlined. But we still have some information that we can still get and be guided by. So, Jade?
Yes, absolutely. And, because I think some of our listeners are challenged with understanding how this legislation would apply to them. So just to break down for them quickly, who is a data controller? So, for example, JFJ, we take cases from persons who need legal assistance. Are we data controllers?
Data controllers are anybody who processes information.
Oh.
So it's very wide, and it covers all persons who process data. Yes, JFJ is a data controller.
So,
And already look at these things, Mr. Gray, and say, how are we going to be meeting them with no encryption and these kind of fancy stuff?
Well, you'll have to put in place measures to protect the data.
Yes.
That may include encryption measures. There may be other security facilities and features available in the various programming spaces that are applicable as well. Encryption may not be the same for everybody else. For some, it may just require them to ensure that each user has a robust password.
Okay.
Oh.
Okay.
So we should be fine then, you're saying, Jade?
I think one of the things that would help, I know that under the Data Protection Act, there is the requirement for a data protection officer. So is that the role of that officer to ensure those mechanisms? And then with that responsibility, what power does this officer have? Like, what kind of person becomes a data protection officer, first of all? I think we'll start with that one.
Well, firstly, a data protection officer is appointed by the data controller.
I see.
That's the first and the most important thing. It is a requirement in registration that all data controllers name a data protection officer if required to do so. Now, the data protection officer has the remit to monitor the data controller's compliance with the Data Protection Act. Now, this is a very serious role in that the Act did not specify the qualifications that this person should have. But what it did specify is that in the role of the data protection officer, there must be no conflict of interest in relation to any other role that that person may carry out. Now, what it means is that in monitoring, the data protection officer will ensure, one, they're liaising with the Office of the Information Commissioner to look at where there may be any doubts or misgivings in relation to the provisions of the statute itself and seeking clarity. They may also receive complaints from the general public or data subjects who may interact with the respective data controller. And in that regard, the data protection officer will want to ensure that whatever matter is brought to attention is addressed by the data controller, bearing in mind the rights and responsibilities afforded under the Act to the respective data subject. Where a data controller may not have managed or responded to a data subject, the data protection officer will also seek to advise the data controller that you need to respond. And if there is any failure on the part of the data controller to respond, to bring to the attention of the Information Commissioner those gaps so that the office can utilize the powers afforded to it to seek to have the matters that have arisen successfully dealt with.
Thank you so much, Mr. Gray. You know, when we first read the Data Protection Bill, and let me start by saying that JFJ supports the Data Protection Act for the most part, but we are concerned, and maybe you can guide us through to allay some of the fears if you could. When you have agencies, because of the expectations of the data protection officer, I said somewhat independent because we can't be conflating their duties as you outlined with some errors. It suggests that I almost, if JFJ is to be deemed as a data controller, as a little NGO, where I'm already going through pains of retaining staff, it seems now I may have to get a data protection officer. Is that recommended, or could persons so identify an individual within the office that substantively and substantially could take on some of those roles, or is the recommendation that such a position is newly hired? What would be the recommendation coming from the office?
Well, when you look at the particular circumstances of various entities, the first thing that we need to ensure is looking at the data that you process. Is it one that is required for you to have a data protection officer. Now, I want to say for the general public that while the focus is on the data protection officer, and a data protection officer is required where you are a public authority, where you handle sensitive personal data, where you are regarded as being a large data processor, or you are also required by virtue of any ruling by the commissioner to have one in place, that the fact that you do process data and you are a data controller, you will have to have in place a mechanism to ensure that the rights of all data subjects are protected and addressed.
Okay.
Right? So the focus now on the data protection officer is because of those 4 criteria that I mentioned.
Yes.
That you handle sensitive data, you're a large data processor, you also are in a class which the commissioner has ruled is required to have it, or you're a public authority. Now, the data protection officer, the methodology of appointment can be an independent hire. You could, if there are possible firms, businesses that offer that service.
Oh, okay.
And you possibly could enter into an engagement with them to be your data controller on your behalf.
Okay.
You could also go the route, particularly where your organization may be sufficiently large, to hire a person and put specifically in that role. You could also be looking through your own organization and you are identifying an individual who you may presently engage to undertake the role of being the data protection officer. Again, we have to emphasize that whatever other role that they undertake, there should be no conflict.
Absolutely.
And we also need to understand that the person that we may be engaging has to be at a level that they're acting independently, and that once they have brought the concerns to the public sphere, which meaning within the organization, that these are handled with expedition.
Yes.
So it's the methodology of appointment is really left to the entities itself, bearing in mind the criterion as outlined.
Great. We're coming up on the break in a few seconds, but a few things I want to probe with Mr. Gray. I wrote this down. If there is like a simplified audit checklist that the commission could assist agencies with to say, have I met these criteria outlined in the act? Because nobody will be reading that act fulsomely, unfortunately. Let me not say nobody. A lot of people will not be reading the act, unfortunately.
I have read it fulsomely.
You're required. It's part of your job, right? But I want us to be guided by that though it's a requirement, we already know the limitations. So what is the role of the commission in guiding people through and encourage them to read it, but understanding that their levels of comprehension may vary? How do we ensure that people are compliant? So public education and the assistance from the commission's office would be something we want to probe on the other side of the break.
Welcome back to Let's Talk Justice. We are navigating our data protection landscape with Mr. David Gray, our Deputy Information Commissioner. And before the break, we were about to ask what, if anything, and what plans does the Commission have to kind of simplify some of the provisions that are in the Data Protection Act to help us data controllers and potential data controllers understand what those requirements are? What if any, public education plan is coming forward from the Commission? Mr. Gray?
Okay, well, in September, the Commission did do a soft launch of its public education program, which will be all-encompassing. It will cover information for data controllers in relation to the rights of data subjects, the process of registration, what does registration entail, the matter of the data protection officer, who is ideal candidate for appointment as a data controller, what sort of systems should you have in place as a data controller to be able to enforce the rights of data subjects and ensure that you process data in keeping with the standards. The office also has been engaged on a bi-weekly basis, publications in our daily press. I think they come out on a Sunday, and they give basic information on the provisions of the Act and how the Act is to be implemented. Over the next couple of weeks, we'll be ramping up our website, and our website will be giving a lot of information. Particularly, we hope to include the feature of the registration process so that persons can do the registration, undertake the registration process online. And that will be a great help. It will take a big burden off of our data controllers to complete the forms manually and make a long trek from all over the country to our offices. We'll also be rolling out a fulsome public education program now on the various sectors. Those sectors may cover the insurance, they'll cover the public sector, the private sector. We'll be partnering with some of our private sector entities that as a whole have as one of their core activities data privacy and data protection. And we'll be targeting certain sectors, the health sector, the credit unions. We've done a little intervention with the credit unions already, the financial sector, to have all of at least our major publics aware of the provisions of the Act and having all the requirements that the Act has set out in place to protect the rights of our data subject. This will, over time now, trickle down to the total population because, as you've quite rightly pointed out, registration is not only for the large entities, but will cover those small business persons who also process data. Yes. And what we'll have to ensure in the design of our public education program is that it is kept very simple and easy to understand, and whatever forms that may be required for the process of meeting the requirements of the Act are easily available and in a readable form that they can be completed by, I don't want to use the word lest it be thought of as being unkind, but the ordinary man.
Yes.
Right?
And you will get our official communication, Mr. Gray, but I do hope that there is space because some civil society organizations, we collect a lot of information and we want to ensure that we're compliant with the law because we can't be in the public talking about law reform and we're not compliant with what has been passed. So we're very cognizant of that, and we hope that there is space for a meeting to be had, not only with JFJ, but our partner agencies as we navigate this landscape.
Well, we look forward if you make the request. Our offices will seek to, as best as we can, given our resources, to have that dialogue, because it's essential for us to have all our partners on board. This piece of legislation engenders partnership. If our partners are not in full adherence with the Act, then our role will become even more complicated and complex. Yes. So once there is full buy-in by all the respective stakeholders, it will make the process of managing, implementing, and enforcing that much easier.
Thank you so much.
Thank you so much, Mr. Gray. We appreciate you coming in. Well, I think that now that we are going into our data protection period, now that we'll have our improved privacy rights, or privacy rights actually realized, there will be a lot greater interest in what those provisions are. So we're definitely looking forward to seeing that simplified, or some of that public education material that you spoke about. And we are certainly looking forward to any further information from the ministry on the regulations that should support the legislation going forward.
And I want to add something to the conversation as we close out. When the NIRA, the National Identification Registration Act, commonly referred to as NIDS, was being contemplated, one of the things my predecessor, Roger Malcolm, and others who had reviewed that act at the time had called for was for a delay in NIDS coming into effect until the Data Protection Act is so commenced, because we recognize when any state agency or any public body or private entity, rather anybody at all, is collecting sensitive information about the core of our being, we have to ensure that those privacy rights are adhered to and respected. So we do acknowledge that the government had recognized this caution, yes, and they so respected and agreed to it. So we're happy that the Data Protection Act is coming into effect soon, and as Jade outlined earlier, and as Mr. Gray advised us, then once the regulations are so passed, then we will see different measures and different steps being taken over the next coming months. But we do look forward to Senator Dr. Dixon, yes, giving us further information on what are the steps, the provisions that will so come into effect based on a stage-by-stage basis, if you will, a very phased approach, yes, based on those public statements. So we look forward to it. But Mr. Gray, we wish you best of luck. And public education is something from our desk we can support the office as we're doing here. So we are heartened by your willingness, and we appreciate you navigating traffic to get here.
Thank you, and thanks on behalf of the office for having invited us.
Thank you so much. All right. Did we have anybody calling in?
Yes. We have.
Oh, she's here? He or she? I don't even know. I'm sorry.
No, they're no longer on the line because there seems to have been some complaints, but I don't know because our winner got through. So I guess the lines were buzzing with trivia question responses.
Oh.
However, we do have a winner. The name is Anissa. Unfortunately, I don't have a handle for her. I have her number, so I can't read that out on air. But Anissa, you'll get a message from us in short order in regards to your prize. But she would have stated for personal data, she considered political opinion, sexual orientation, sex life. What we gave it to her for political opinion and sex life, as those are under the sensitive personal data. But just for our audience who has been listening to the discussion, under the Data Protection Act, your sensitive personal data is personal data that includes your genetic or biometric data, your racial or ethnic origin, political opinions, philosophical beliefs, religious beliefs, or other beliefs of a similar nature. If you're a member of a trade union, if you have physical or mental health condition, your sex life, and the alleged commission of any offense by the subject or the proceedings for any offense that you would have been alleged to have committed. All of those things constitute personal data. I'm being corrected by our producer to note that Anissa did in fact say trade unions. So Anissa, thank you so much for participating. You will receive your double prize by virtue of having called in. And I think we're now in our second half, Ms. Jackson.
Well, I'm going to ask our tech op, Kevin, just to allow us to take an early break so that when we come back, we have some discussion on that judgment last week. Maurice Tomlinson Bugre Law. We're going to be touching on the implications of the Savings Law Clause and what all of that means for human rights in our country. We take the break.
Well, welcome back to Let's Start Justice. So we just had a conversation about our data protection landscape, and we're now going into our second half topic, which is on the matter of Maurice, the secondary matter in the Maurice Tomlinson legal challenge, where they would have been inquiring into whether or not the court could inquire into the constitutionality of certain sections of specialized legislation. So Ms. Jackson is going to elaborate on that.
Well, we know commonly what is referred to as the Buggery Law in the country, which is 3 sections of the Offence Against the Persons Act.
Well, the actual act, the actual buggery provisions are section 76 and 77, which speak to the actual act of buggery. However, section 79 goes further to criminalize, what it calls it gross indecency, but to criminalize certain actions between two men that are not buggery, simply affectionate actions possibly are criminalized under that section.
Now, Ian Wilkinson, Casey, who represented Maurice Tomlinson, urged the judges to be bold, were the words that he used, asking for the Buggery Law to be so deemed as unconstitutional. And though we weren't entirely surprised by the ruling, I personally can't help but feel somewhat disappointed. I don't know if you can be disappointed by something you weren't surprised.
Yeah.
But you can't help feel disappointed because you see the implications of the Buggery Law being retained. And we've articulated before that when we gained independence as a country, we had what was called the General Savings Law Clause, which helped us as a newly independent nation to transition from the colonial powers that had oversight, if you will, of our governance structure. As an independent country, it was a transitionary clause as we look at how we want our laws and governance framework to be. That was the purpose of the Savings Law Clause. It wasn't intended to retain what I can deem as state discrimination. Now, when our government was reviewing the Charter of Fundamental Rights and Freedoms, they removed the General Savings Law Clause and they had what we now call the Special Savings Law Clauses, which speaks to buggery not being able to be constitutionally challenged, matters of abortion.
It speaks to sexual offenses, matters of abortion, and obscene publication.
Yes. Yeah. Which has implications for death penalty as well.
Yes.
In other countries, it varies, and I use the example of Trinidad because we saw where there was a challenge recently, which was not successful. It was challenging sedition in that country.
Yes.
Now, the judges are correct on the matter of what is in the law. The letter of the law is correct in this regard. Yeah?
Yes. They're simply saying the Savings Law Clause prevents the court, the constitutional court, from inquiring into the constitutionality of these provisions.
But who the interested parties are very interesting to me.
Indeed.
The churches. And Justice Batt quoted Barack Obama, and he said, "What our deliberate pluralistic democracy does demand is that the religiously motivated translate their concerns into universal rather than religion-specific values. It requires that their proposals be subject to argument and amenable to reason." And while Justice Batts recognized that it is not within the remit of the court to act in that regard, and he rightly said that Parliament must act, but he also spoke to the importance of separation of church and state.
Yes.
And I found it to be quite instructive. Because at some point, we must recognize how the retention of the Buggery Law and how we are when it comes to religious views, having significant implications and consequence for minority groups in this country. Now, the politically correct thing to do for most civil society organizations is to speak on buggery from the place of its implications for sexual offenses specific to rape being defined in law. We understand it. We stand behind it. We have articulated it.
Many times.
That the Joint Select Committee of 2018 said that they would not be recommending that rape is so redefined so that men and boys are protected because they believe that it may have implications for the buggery law. And in that regard, they want to put it to a referendum. JFJ goes beyond that to say that at some point, the rights of the LGBTQI population must be respected. So we look at it from two sides of it, that the church ought not to be dictating what they deem as family values in this country to the extent that vulnerable groups are being discriminated against. Or you find that you see the headline, a child is buggered, but the perpetrator can only serve a maximum of 10 years. I think it's an injustice that ought to be corrected by Parliament.
You know, I just wanted to add a little bit of context for persons, because I think especially when we do our public education around this recommendation,
yes,
persons are surprised to find that these sections apply no matter where you are.
Mm-hmm.
If you are in your home with all the doors and windows locked, and a police officer has information that you are in that home performing or partaking in buggery with any partner, because this is even outside of the LGBT
But
community.
I was about to ask her, who is the you?
With
Because
any partner. So if it is you
heterosexual,
and your wife
yes,
engaging in buggery in your home,
Mhm.
that gives the police one permission to enter your home without a warrant, to search you and arrest you and your wife, and they would have seen that offense in plain view. So it is proven.
Mm-hmm.
And that is immediately your 10-year sentence, depending on the court, of course, but your maximum sentence would be that 10 years. That is in the privacy of your home.
And we're talking about right to privacy in this conversation
Absolutely. So as we
Mhm.
even spoke about the Data Protection Act and it codifying that right to private home and private information and private communication, we are still in this contradictory phase of having these provisions that simply disregard that privacy. And we have specific provisions that deal with public indecency. We have provisions that deal with if you were performing this action in the street, for any person who would be performing any sort of sexual action in the street. So the concern is to police what is happening in the private homes of persons, and that cannot be where our legislative thought is at this time in our history and in our future.
Well, I'm going to borrow Casey's urgings that he made to the judges, wherein I'm urging the parliamentarians to be bold. Let human rights actually mean something. We cannot subject people to the views of the majority, to the discriminatory actions of the majority, where we fail to protect people's right to choose, people's right to be, as well as fail to protect our men and our boys in particular. So we want to make that urging, because as we outlined earlier, moving it out of the conversation of buggery, the savings law clauses do have implications for abortion. When we explain to a vulnerable woman that if it is, for example, you were raped, or if you realize that, listen, based on a decision that I took in the moment, a consequence is that I'm now pregnant, but I have my right to choose. I do not want to carry a child to full term. That you will get life imprisonment. How is that just? When you tell a doctor that be guided by a policy that really no longer exists, that you can get life imprisonment, How is that a just society? I want us to think on these things as a country and think beyond what we have been taught. That you don't have to do the action if you don't believe in it. But the law must recognize persons' freedom to choose and do what they must if a particular circumstance affects them. I do not believe any church group should be policing my rights or my parliamentarians whom I have voted for to act in my best interest has subverted my rights to a special interest group. I reject it completely. And I would ask again, parliamentarians to be bold, but our citizens to recognize the implications of these pieces of legislation, the savings law clause, and call for it to be repealed in its entirety. In 2023, we should not be having this conversation in the country. Interestingly enough, the United Kingdom that we borrowed our laws from, you need to go and ask what they have done with it.
Have you seen their coverage of the result of our matter?
No, I didn't.
Oh, it's poor. Their perception of us is that we are so far behind. That we are trying so hard to maintain something that we've inherited from a country that now sees us as backwards for trying to maintain it.
But you know what I find instructive? I look at how people view other countries like a Cuba.
Yes.
You need to go and check out Cuba's law on issues such as these and corporal punishment and so on.
Yes.
Far ahead.
Quite
than
far.
A country that claims to be a liberal democratic one. Food for thought.
Indeed. Well,
right. Oh, we announced the winner?
Yes, we did announce our winner.
Oh, we have a couple of things to make, to announce for JFJ. And I had much more to say, Jay, but I was there giving her the time to announce the winner, but apparently we already did.
Yes, we did, ma'am.
All right, couple of things to announce. For the 25 days of activism.
I thought it was 16.
Oh, 16. Yeah. What am I thinking? I'm thinking about our 25th
yes,
anniversary.
Thinking about our 25th.
All right. You see, I'm really getting all the gray hairs and so on, getting the best of me. But just to indicate that we have some activities coming up for the 16 days of activism. That is where we celebrate how far we've come regarding gender-based violence and calling for our legislators to act and to campaign for the rights of women. So during that 16 days that commence on November 25,
yes,
and it goes up to December 10th,
yes,
which is Human Rights Day, JFJ, we have some activities. We have 2 closed-door sessions. They're by invitation only. That's a breakfast forum with private sector entities and the role they play in advancing and addressing gender-based violence. We also have a Human Rights Day reception on December 10th, and that will be held at a venue that I can't disclose. But a very public event that we have coming up is December 8th.
Yes, December 8th on Friday, we will be at the Halfway Tree Transport Center, and we'll be having our Human Rights Day community intervention, and we are inviting you all to come out and join us.
Come join us and come with your sign and your excitement and call for justice reform in the country.
Yes.
Let our parliamentarians know that the Domestic Violence Act, we don't want one more year of announcement. We want the act actually being not just submitted in Parliament, but actually passed.
Absolutely,
yes.
Absolutely.
So come run out with we.
Yeah, but it's not just that. We have the information there as well. So
yes.
If you want to know something, the whole team will be there to be giving out all of that relevant information. So it will be a fun day as well. There will be prizes and surprises outside broadcast.
But we're not advertising anybody else on Bridge 19. I won't do it at all. But
yes, so the excitement will be there. So keep watching our pages, JA for Justice on Instagram, Jamaicans for Justice on Twitter, and our further announcements will be forthcoming. So thank you for joining us this week. We'll be back next week at the same time, 1 p.m. So this was Let's Talk Justice. I'm Jade Williams.
And I'm Mikkel Jackson. Take care.